Who gets to decide your gender, you or the state? The new Transgender Amendment Bill introduced in Parliament in March 2026 shifts the power away from transgender people back to doctors and bureaucrats. Under the previous Transgender Act of 2019, a transgender person had the legal right to self-perceived gender identity. In simple terms, the law recognizes that you are the authority on your own gender. The bill introduces a state-appointed medical board and gives the district magistrate the power to examine the board's recommendation before issuing a certificate recognizing someone as transgender. At first glance, this may sound like a bureaucratic process, but in reality, it changes a fundamental question. Instead of asking, who are you, the law begins to ask, can you prove who you are to the state? This shift matters a lot because it appears to reverse the logic of another landmark Supreme Court decision. In Nalsa vs. Union of India 2014, the Supreme Court held that gender identity is a matter of self-identification. The Supreme Court described gender identity as an innate sense of one's gender and explicitly ruled that trans people should not be forced to undergo medical examinations or biological tests to prove who they are. Think about a young trans person living in a small town in India. Under this new system, they may have to appear before a medical board, convince doctors of their identity, submit medical documents, wait for review by the district magistrate, possibly undergo further scrutiny before a certificate is issued. Think about it, for someone already facing discrimination from family members, hospital, police officers and government officials, this process of just getting a certificate can become deeply humiliating and intimidating. So for many trans people, especially those who are non-binary, trans-masculine or not pursuing surgery, this system becomes exclusionary because not every transgender person wants or can afford medical transition. See, another concern is that the bill also raises serious privacy concerns. According to the bill, medical institutions must report details of gender-affirming surgeries to the district magistrate and the authority. In India, where disclosure of trans identity can lead to loss of employment, housing discrimination, or even violence, privacy is a safety issue. The law effectively says that in order to live legally, a trans person must become more visible to the state than cisgender citizens ever are. But perhaps the most worrying element of the bill lies in how it treats trans community structures. For decades, transgender people in India have built their own systems of survival. Many trans people are rejected by their families when they come out. In response, trans communities developed alternative systems of survival. Hijra gharanas, community houses, chosen families, support networks. These networks provide housing, mentorship, emotional support and economic survival. See, if the law treats these structures with suspicion, it risks undermining the very system that have historically kept trans people alive in this country. So in effect, the law could reinforce the conservative idea that only the biological family and the state are legitimate authorities over gendered life. The bill therefore becomes part of the larger struggle. Who has the authority to define gender? Is it the individual who lives that identity or the state that certifies it?